Good evening. Today is October 20, 2025, and it's 10:25 p.m. U.S. Central Time. My name is Rinaldo J. Aguiar Marcano, and I'm recording this video from my home located at the 26714 Valleyside Drive, Katy, Texas, 77494. And this is just a short video to ask a couple of questions to that person that is helping me. To not send it through the other channels. It's a legal question. Hoping that you could, route it to the lawyers, right? So I run the question is I run the legal vaccine, and because of the observations that I mentioned this morning, right? The notice of entry, the notice of appearance, I think it's called, of that lawyer that was in the appellate court case now showing up in the family case, right? In the lower court case. And also that weird document that was called motion order, right, of withdrawal. And they were requesting my signature, which, like the title on itself, it's confusing, right? Is it a motion or is it an order? And if it's an order, why do we need to agree, right? An order is an order. You don't need to agree to an order. An order is something that you have to comply with, right? You don't have to agree to an order. You agree to a proposal. So, and like, because I know at this point that they play with the titles of the documents to either confuse the opposing party or to harass them or to commit fraud, right? Like that's demonstrated at this point. Case in point, when Morgan Heibner in April sent me a proposed order, but she didn't say that it was proposed. She said order, right? Like trying to make me believe that it was an order from a judge, right? But it was really a proposed order that she wrote, that she made up, right? And another example is that fraudulent document that she filed with the 387th court to deceive the appellate court, right? The first appellate court. So I know that they changed the titles, right, at this point to even commit crimes, right? And this document is suspect because it says order and says motion, and then also says agreement, like three different things in the title, right? But anyhow, the question is the following. I'm running all this through the pipeline, and well, side note, I think I'm gonna make a meme about this, right? Like achievement unlocked. Like the pipeline cannot find any cases in Texas in the history that it has of cases in which this situation has happened, right? Meaning that one party wants to withdraw the attorney while there is a second motion to recuse the judge. Like this has never happened before in Texas, apparently, from the data I have, right? Now, and this is the question, right? I believe, from what I'm seeing in the pipeline, that they can't unilaterally withdraw Morgan Heibner, right? It is not something that they can do unilaterally. They need either my agreement or the judge approval, right? They have to file a motion and the judge has to give an order, right? Authorizing that to happen. And again, this is why I need to ask a question, because I don't know the rules on this, right? But I imagine that this is because this could prejudice me, right, and my interests. For example, the obvious reason is Morgan Heibner had already committed at least 4 different frauds, right? Like the 3 fraudulent temporary orders draft that she wrote, making up stuff the judge never said. That's 3 times, plus the document she filed with the fraudulent title, deceiving the 2 courts, right? So of course, I don't want Morgan Heibner to go anywhere, right? I want her to not go to stay, right? Because I want her to be held accountable. I don't want her to disappear. into thin air. So if it's up to me, I would oppose that. But I think for me to oppose it, they have to file a motion first. And the problem is that the judge is there is a motion to recuse the judge, and all the matter is stayed. Like no motion can be decided on or ruled on until the motion to recuse is processed, right, and ruled on by the administrative judge. So it seems like everything rests in the hands of the administrative judge at this point, right? That's what I'm seeing in the output of the pipeline. But I don't know if there are any exceptions or any rules that the system is not aware of that they can use to withdraw her, right, by force in some way. I don't know, right? So that's the question. And so maybe that's why they named the other attorney lead attorney, right? Because they can really withdraw this one, right? It's not otherwise they would have named him the attorney, right? And just withdraw Morgan Hypner. But now the petitioner has two attorneys, right? A lead attorney and Morgan Hypner. So she really has a legal team on this, right? And she only has, well, she had $9,000 in her bank account in September 8th. That's when Morgan Hypner said it, right? So more than a month ago, she had $9,000 in her bank account, but now she's paying two lawyers. So I don't know. It seems like a complicated math to me. Yes. So it's a bit of a sticky situation that they have, right? Because I don't know how they're going to withdraw that lawyer when they can't file a motion, right? So that's the question, basically. If you can ask, the lawyer if if I have any recourse to make them not be able to withdraw the lawyer, right? That's the question. Well, thank you so much for helping me with this. Bye.